All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When you hear your name, please say present or here so I can acknowledge you. Giovanni Chavez Rosales. Brandon McClanahan. Cody McCoy. Cody Lee McCoy. Hayden Mitchell. Joshua Nowak. Jeremy Snelson. Xavier Trejo. Jake Wilson. Michael Zimmerman. Michael Cody Zimmerman. Felix Diaz. Megan Tyler. Megan Tyler. Johnny Cooper. Here. James Dennis. Here. Benny McFarland. Miranda Opry. Miranda Jill Opry. Alfonso Perez. Yes, sir. Patrick Rowe, waiver of arraignment filed, pretrial set August 10th. Both cases. Eric Sperling. Here. Tyler Tadlock. Here. Marcus Turner, CR 21343, set for status on Kaufman County custody. We verified he's still in Kaufman County as of yesterday. We'll recall that, Mr. Manning. Kenneth Warrington. Lindsay Miller, CR 23113, waiver of arraignment filed, approved, pretrial set August 8th. Josue Rodriguez.
President, Your Honor, he is on his way. That's what. Second now.
Says. Christopher Shoemaker.
Counsel, Your Honor.
Thank you, sir. Adam Chronister.
Here.
Wendy Price. Mary Robinson. Is there anyone who's present in the courtroom? You're on the docket. You believe that you're on the docket, but I'm not called your name. And let's see. Are you Mr. Flores Laredo? Right, let's see. Mr. Altum, I believe that we have an interpreter lined up for 9:15, so I'm going to call you first. Good morning, Maria. Can you see and hear me okay? All right, let me try that again. Maria, can you see and hear me okay? Let's see, I'm having some difficulties here. I know I've got no audio. Maria, can you hear me? No. Can you hear me? That's. Maria, if you can hear me, let me try setting you up as the interpreter again, because it says the original audio says interpretation is off. When I click on the English channel, I added you as the interpreter, and I selected English channel as I always do. For some reason, it's saying original audio interpretation off. I'm not sure why it's doing that. Yes, I can't hear you now. Yes. Okay. All right. No problem at all. All right, Maria, let me go ahead and swear you in before we get started. You'll raise your. You'll raise. Go ahead. Go ahead. Go ahead. Go ahead. See? Oh, thank you, Maria. If you'll go ahead and state your name and your license number. All right, ma'am. Do you swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment? So help you God. Thank you, ma'am. All right. This is cause number CR 23-28. This is the state of Texas versus Felix Diaz. And I believe that we are set for pre-trial today, Mr. Alton, on the evading arrest or detention with a vehicle. Have you received your discovery? Are there any contested pre-trial motions or any other issues that the court needs to take up?
There are no contested pretrial issues at this time, Your Honor. We, in principle, have an agreement with the state for a plea. However, Mr. Diaz may have some immigration issues. If he accepts that offer, I will set him up with an immigration attorney. Should be reaching out to him. And I've spoken with the state and requested that we be allowed to reset this case in order to allow him to get some good advice on whether or not that's going to be a problem.
Okay. All right, then. Court finds that there are no contested pretrial issues, that the discovery has been received by the defendant. Or within set Mr. Diaz for hearing on docket call announcement for announcement whether there's going to be a plea agreement or a trial. Are you available on July 11th or 13th, Sean?
I'm available on the
11th. All right, Mr. Diaz, then the court's going to order you back on July 11th at 9:15. Can you check, see if there would be anyone available on that day, July 11th at 9:15? You could schedule one for us, that would be great, and then that would save Ms. Abraham the step. Sure, sign yourself if you so wish. All right, Mr. Diaz, Mr. Diaz, if he has any questions, Mr. Alton for the court at this time before we let him go. Okay, we'll see you back on July 11th at 9:15 a.m. Thank you, Mr. Alton.
Thank you.
All right, do we have any other counsel that's ready to go? Yes, Jim, I believe for now, I believe that we will have a 10:30 hearing. I'm not sure if you're on that case or not for Juan, Flores, Laredo at 10:30 a.m., but okay, great. Very much. Uh, yeah, let's disable it and then I'll redo it whenever the interpreter comes back at 10:30. I mean, yes, ma'am, it is. Let's go ahead. Got it.
Manage language interpretation. And just click the red button that reads end.
Got it.
Done. Thank you, Your Honor. May I be excused now? Thank you. Thank you so much. Take care.
Mr. White, who are you ready on?
Mr. Cronster.
Adam Conister, CR 23-26. Conister, set with pretrial. Mr. White, go ahead.
Your Honor, we don't have any additional pretrial motion. We'll abide by the standing order of the court. We asked the court to send this over to docket call. Would note to the court, we do have an additional situation over in Plains County. And possible, I'd like to kind of be able to get everything kind of lined up in both counties. Just making you aware of that.
Does he have anything scheduled in Reigns County next month?
Next week, June 22nd.
You're available July 11th and 13th.
I'm gonna be up here on July 13th, John.
All right, Mr. Cronster, we'll see you back for Dr. Call on July 13th. Once you sign your notice of appearance, you're free to go.
All right, yes, sir.
All right, Mr. White, you ready on next?
Miss Price.
Wendy Price, CR 22-339. Price is set for Dr. Call.
Your Honor, this was originally Ms. Heisel's case. And I had a chance to speak with Ms. Curry about it. And I believe that we're still trying to get to a resolution on this. I think if we could have 30 days, I think she would join me in that request. I think we have a chance to get this worked out.
Okay. All right, court will set Ms. Price for a final docket call on July 13th. At 9 AM. Once you sign your notice of appearance, you're free to go, Ms. Price.
Your Honor, could you please give me the cause number on that again?
Yes, ma'am. I'm sorry, yes, sir. CR 22-339. CR 22-339. Like, ready up, Ms. Robbins.
Your Honor, that's going to be a plea.
Okay, just wait. All right, Mr. Wall, so Mr. Wall, he said he was ready. Are you ready, sir?
Thank you, Sean. My class, I have action currently, but we are ready.
All right, go ahead and bring him up.
Thank you, Judge.
You're welcome. This is cause number CR 23-00074. This is for pretrial. Mr. Walpole, any test pretrial motions or issues with discovery?
No, sir. We've received discovery. I've had an opportunity to review it. We will need to schedule my client for a PSI.
All right, court will set Mr. Shoemaker for docket call. Are you available on July 11th and 13th?
Judge, either one. Either one's okay with me.
Okay. It's set for July 11th. All right, fill out the notice of appearance, and then, but there's been a request by the pretrial release department to conduct your analysis test on Mr. Shoemaker today. So once he signs that notice of appearance, he can go over here and have a seat. There's a pretrial release officer for drug testing today,
Yes, sir. What time on the 11th?
9 AM.
9 AM. Yes, sir.
So typically real our PSI.
Yes, ma'am. Any other council concern?
You're on that. Mr. Jose Rodriguez.
All right. This is cause number CR 18-503. Hearing on the motion to revoke for Mr. Rodriguez. Go ahead, Mr. Rosales.
Yes, Your Honor, I would ask if we could get one reset. We were retained since the last setting. I have spoken to the DA's office. I believe we will have this matter taken care of before the next setting. If all goes well, we're hoping to have this withdrawn.
About we don't have the document in 2 weeks. Is that June 29th?
I will be in Kaufman County on that whole week.
Do you anticipate having a plea or do you anticipate having a contested hearing?
I don't anticipate having a contested hearing on this matter.
So you anticipate a plea?
Yeah, as long as he gets back on track, we anticipate hopefully getting this withdrawn and moving forward on continuing on probation.
You're gonna call all day.
I could be here potentially late in the afternoon on the 29th.
What's going to shut it for the contested hearing on July 5th?
July 25th, you're on.
July 25th at 9 AM.
Thank you, Judge. And if we get this resolved before then, we'll get it taken care of.
Yes, sir. I've got plenty of settings before July 25th, so just let me know.
Thank you, Judge.
Are you ready, sir? Yes, you may. Brandon McClanahan. Come on up here to the podium. All right, this is cause number CR 23-109-0, State versus Brandon Dwayne McClanahan. Mr. McClanahan, cause number CR 23-109, you've been indicted with the offense of taking wildlife resources without consent, a class A misdemeanor that has a range of punishment if convicted. To not more than 365 days in the county jail, a fine which cannot exceed up to the maximum $4,000. In CR 23-1.0, you are charged by indictment with a third-degree felony offense, unlawful possession of a firearm by a felon. That has a range of punishment of not less than 2 years in prison, but more than 10 years in prison, and a fine not to exceed $10,000. Do you intend to hire an attorney or represent yourself?
Yes, sir.
Which one? Hire an attorney. If I reset you till July 11th or 13th, would that give you enough time to hire an attorney?
Yes, sir.
Okay. Can I get those sheets? You prefer July 11th or July 13th? One's a Tuesday, one's a Thursday.
The 13th.
All right, Mr. McClanahan, I'm gonna have this announcement form brought to you. I'll need you to sign right here for says defendant. Says that you're coming back on July 13th for arraignment with your attorney. All right, Mr. McClanahan, you got one more thing I need you to do. As a condition of your bill, you're gonna have conditions of pretrial release, all right? So I'm gonna have you come over here and meet with my pretrial release officers or piece of paperwork. There's gonna be conditions that on your any trial in this case, that you're gonna have to comply with. You're gonna have to record, be drug tested, not be venue off. So if you violate any of these conditions of pretrial release, the court can revoke the bail that you've already posted in this case, put you back in jail. Okay? So, go ahead and bring your form with you, go here, meet with the pretrial release officers and they're giving you information. Aiden Mitchell. This is cause number CR 21-403, CR 21-406. Mr. Mitchell, any information for the court on the attorney hired?
No, sir, last month I went back to court, just for the last thing, and they put me back in jail, so I just got back out. So,
So what are we gonna do?
whatever I need to do. I gotta give it a time.
I understand that. I've already ordered you to do that. How are you gonna do that? When are you gonna do that?
If I can reschedule it, I can have it 2 weeks next time. Sure.
Reschedule for how long?
I got court again, which is 29th.
Tell me how long? 2 weeks, 3 weeks, month, what? How long do you think it's gonna take you to get it?
I would have one by next month for sure. I just gotta get some work on my bill.
All right, I'm gonna reset you to July 13th. That's gonna be the last time I ever reset you for this. If you come back without a lawyer on that day, then probably just gonna find your bail insufficient, put you back in jail. Once you sit there long enough, at some point you'll become indigent. Or have to wait. All right. All right, Mr. Mitchell, you're gonna sign this and then come have a seat over the jury box. And have your drug test. Ready? Yeah. Are you ready, sir?
Judge Richard, Mr. Perez.
Alfonso Perez, CR 23-67. Thanks, sir. You as well. All right, Mr. Perez is set for arraignment today. Go ahead, Mr.
Yes, Judge, we've had opportunity to review the indictment. At this time, because of the recency of the appointment, we have not been given discovery. In looking at the indictment, my client would like to inform the court that his name is not spelled correctly. His first name is spelled as follows: ALFONSO. Beyond that, he understands the charge against him. He requests to be set for future trial, pleads not guilty.
Short statement.
State which the indictment.
All right, court will grant the state's request for amendment to the indictment to reflect the correct spelling of the defendant's name as Alfonso ALFONSO Perez Jr. Court also enters Mr. Perez's plea of not guilty into the record and finds that he's waived the formal requirements of arraignment. Court will set this matter for pretrial hearing August 10th.
Such a
Mr. Manning, on conditions of pretrial release, I see that Mr. Perez is delinquent $160. I want you to address that with your client, have your client of being pretrial release, make the payment today.
absolute judge.
All right, Mr. Manning, ready for service.
Ready on Mr. Johnny Cooper.
Johnny Cooper. CR 20-326 and CR 20-239. Show that Mr. Cooper is set for Dr. Paul.
Yes, Judge. Mr. Cooper informed me this morning that he and his family have retained Mr. Justin Weiner.
Is that true, Mr. Cooper? Yes, sir. When did you retain him? Did you tell him about today's setting?
Yes, he's going to tell you. Attorney.
Did he file a letter of representation? Usually when you hire an attorney, they
I just sent him one yesterday.
all right, have a seat. I'm gonna recall you in just a moment. I'm gonna ask that Mr. Weiner appear by Zoom.
I took a speed with Mr. Weiner yesterday. I looked at my comments on the time. Part of the independent conversation. At that point, he had not been paid. But he was going to call Mr. Weiner, get paid. I did discuss with him that we should probably follow that from.
Go ahead and have a seat, Mr. Cooper, and we're gonna contact Mr. Weiner's office and I'll recall your case. Manny, are you ready on anyone else?
Yeah, next we have Mr. James Dennis.
James Dwayne Dennis, CR 23-10. Sure that Mr. Dennis is set for docket call.
Yes, Judge. Mr. Dennis received a new plea offer today, that was extended. I had received that plea offer previously, but had been unable to communicate with him, regarding that plea offer. It is for time, and he requests some time to, consider that offer and get his affairs in order. He requests a recess to August 10th.
The objection is stated. There being no objection, the court will grant that request, set Mr. Dennis for plea August 10th at 9 a.m. Mr. Manning, I see that Mr. Dennis is delinquent $320 on pretrial release.
Judge, my understanding is he has been paying on the CR 2310 case. And he just made a payment last month on that case.
This is reflective as of today, so.
Judge, he can't make he informed me he can't make a payment today, and we'll have to do that after. That's important.
Who's next?
Judge, next ready on Mr. Eric Spurling.
Mr. Sperling, if you'll come forward. CR 22-57. Sperling set for pretrial.
Yes, Judge, we have no contested pretrial issues at this point. A request to be set on docket call.
All right, court sets Mr. Sperling for docket call on August 10th. 9 a.m. Also show that Mr. Sperling is delinquent on his pretrial release. What kind of payment can you make today?
Pay $150 at least. The only thing, like I was delinquent because last time I was here, Mr. Waddell was here. I didn't get a chance to talk to him, so I wasn't really clear about what I needed to do about it.
Okay. All right, sign your notice of resetting for August 10th and come over and meet with the probation department, pretrial department. They'll give you info and then make that payment.
Mr. Tyler Tadlock.
Mr. Tadlock, CR 23-76. Tadlock is set for pretrial.
Yes, Judge. My last conversation with the DA's office, there was several charges that Mr. Tyler had been arrested for, and this is the only one currently indicted. I would like additional pretrial for us to figure out what we're looking at for totality of his cases.
Set that for docket call and wait for the, is there any contested pretrial issues on this case? If not, I can set you for docket call and then give
Judge,
y'all time to figure out if the other cases are gonna be indicted.
Judge, there's several cases that they're intertwined. And so I would like to not advance too quickly because they are interconnected. And if we get on docket call and announce ready on one, the evidence and the others may shift our positions.
We have no objection to resetting pre-trial. Try to put some issues together.
All right, we'll set Mr. Tadlock for an additional pretrial on August 10th at 9 a.m. Once you sign and get the notice of setting, you're free to go. You ready on that, Mr.
Judge, Mr. Kenneth Warrington.
Kenneth Warrington, CR 22-257. Warrington set for pretrial.
Yes, Judge. We have no contested issues. We are in negotiation with the state, and request to be set on docket call.
All right, there being no contested pretrial motions, court sets Mr. Warrington for docket call August 10th at 9 AM. Once he signs and gets his form, he's free to go. All right, we'll go ahead and call Marcus Turner and reset that as well. CR 21-343. Mr. Turner is verified in custody in the Kaufman County Jail. Is there any update from the state on defense in this case? All right, court will reset Mr. Turner for status on custody in Kaufman County, August 10th. County.
Judge, we have paperwork on Mr. McFarland. I'm gonna go speak to him on that. And we should be back shortly. Additionally, I received information that Ms. O'Brien is on her way, and as soon as she's here, I'll have her. I'll have her. That's good. Thanks.
Jeremy Snelson, CR 23-119-120. Right, Mr. Snelson. You've been charged with a Class A misdemeanor, taking wildlife resources without consent that carries a range of punishment up to a maximum 365 days in jail with a maximum $4,000 fine, and also unlawful possession of firearm by a felon, a third-degree felony, which has a range of punishment of not less than 2 years in prison or up to the maximum 10 years in prison, and also a fine which cannot exceed $10,000. Court finds that you have applied for a court-appointed attorney. The courts reviewed the information you've provided, and you do not meet the requirements under the law for a court-appointed attorney. So what I can do for you, Mr. Snelson, is I can reset your case, give you about 30 days to hire an attorney. Or you can also consider representing yourself. So. 30 days. Okay. All right, court's gonna. Putting you. All right, Mr. Snelson, I'm gonna have you sign here. It's gonna say to be back on July 13th at 9 AM. I wrote down what your charges are on this form, so that when you talk with an attorney, that'll give them more information. And when you go to speak with an attorney, if you're unable to hire or support that attorney, then consider speaking to several attorneys. Okay, or just call one and get a price and say, oh, I can't afford that. They come back here and say, that's not gonna be helpful. I want you to keep calling and you can find an attorney that maybe will work with you. Okay, yes, sir. Well, I know, I'm assuming since you talked with him, you had this paperwork. Yes. Okay. Xavier Trejo. All right, this is cause number CR 23-78. Mr. Trejo, I believe that we're reset to hire an attorney. You hired an attorney?
No,
Why not?
that's financial trouble. And like, when I spent so. I'm massive pain. And that was resolved. Not a bad, but. But I really got approved. I really got approved for a loan to try to get one, but that was way too late,
That was what?
too late, like, it was like a few days ago, that's when I got approved for a loan.
You did get approved for a loan?
Yes,
How much is the loan?
5,000.
Okay, so as you stand here right now, you have the ability to go hire an attorney based on that loan?
I haven't got it yet, but I could,
When does the loan process and you get the funds?
the end of this month.
The end of June. You're telling me if I set you for July 6th, you'll come in here and you'll have an attorney? Right, court will. All right, court will set Mr. Trejo then for arraignment and status on attorney to hire an attorney to July 6th. 9 a.m. All right, Mr. Trejo, if you will sign here, we'll give you a copy of that. We'll see you back on July 6th. That's what you have an attorney with you. If you don't have an attorney with you, we're going to talk about why you're on bond and you can pay your bondsman, but not have an attorney. Is Michael Zimmerman here?
For Mr. Zimmerman, I think they needed, Dallas County, when I was looking for this there, June 6th, I had not confirmed.
Okay, thanks, sir. All right, Mr. Rosales. It's a sanctions court hearing. CR 21-283, State versus Giovanni Chavez Rosales. All right, Mr. Rosales, I think the last time you were here, you were sick. We sent you home. Feeling better? No? See, that's at the last setting before you were reset. We had a couple things for you to do. You had to pay 120 to probation, 120 to collections, do 10 hours of community service. I saw that you went 1 for 3 on that. You paid your probation, but you didn't pay collections, and you did do your community service. My paperwork says you didn't. Do you have receipts showing that you did?
On the probation or
The court collections, fines, court costs, restitution. Those things. the same amount, just one goes to probation, one comes to the courthouse.
Just say it.
Tell you what, come over here and meet with, Spurs, let her look at that and then I'll call you back up. All right, Mr. Rosales.
If I was gonna say, if you would like, okay, I think by. Okay, or this month, or next month, I could pay $500 each. If you're willing, if you want me to do that.
What about your community service?
Not sure, I don't have the paper on me. I couldn't find it, I was looking for it this morning. But I did 10 hours, but I can't prove that to you.
You understand that's important to prove things to me?
I'm sorry.
Authority doesn't keep you out of jail, my friend.
Yeah.
You gotta be squared away in your mind, otherwise your liberty gets taken away and you get put in jail. It'd be dumb to do community service and not keep up with it, not turn it in. Have done everything to stay out of jail and end up going to jail because you're not turning it in.
If you will let me, I could do 40 hours and I could pay 500 each.
So if I reset you for 30 days, you're saying that you can make a $500 payment.
500 each and 40 hours.
How are you gonna do 40 hours? Are you gonna go work first Monday? Work a Thursday to a Sunday,
To Saturday, they don't have some days, they have church
Whatever.
Sundays, yeah,
whatever it is. You know,
I wanted to go every day.
All right, so what we're gonna do, Mr. Rosales, I'm gonna reset you to August 8th. And I'll do what you say. Instead of you doing what I say, I'm gonna do what you say. I'm gonna honor your promise to pay $500 to probation, $500 to court, and 40 hours of community service. And I even set you out a little bit longer to give you a chance to do that. You're telling me you're gonna get that done?
I managed to get a second job, this, like, I managed to apply for another one.
All right. Come over here and see Ms. Burns and I'm gonna get that picture. And so, listen, just so we're clear, if you don't do those 3 things, it's gonna be a day in jail for everyone you don't do. So, okay, all right.
Yeah.
Serious.
He's got it.
You're free to go.
Oh.
Thanks. Morning, Mr. Frost. Can he hear you okay? You can. Okay, great. All right, good morning, Mr. Corrales. If you'll go ahead and state your name and your license number for the record. All right, Mr. Cross, if you'll raise your right hand, I'll place you under oath. Sir, do you swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness now on trial to the best of your skill and judgment? So help you God. All right, thank you, sir. Thank you, sir. All right, this is cause number CR 15-296, State versus Juan Daniel Flores Laredo. And you have 7 pre-trial today. Mr. Strong, go ahead.
Good morning, Your Honor. Edward Estrada on behalf of defendant. We are present and ready. Just to give the court some background on this, the defendant was just recently arrested. I know the court will see the indictment, so CR 15. And so I just wanted to educate the court a little bit about the matter. After the accident, Mr. Flores went to go for a voluntary non-custodial interview and was later released after the interview. Was never arrested afterwards. Was under the assumption this case may have been resolved because he hadn't heard back, and was recently arrested a few months ago. And so that's what brings us here today, Judge. And one of the things, we're having a bit of issues with discovery. I think the state's looking into to certain videos, and one of those videos that I do need is that interview, that non-custodial interview that Mr. Flores did conduct. In addition, if there's any videos of the investigation after the car accident, the state is diligently looking into to see if those videos do exist. I believe that they did locate the non-custodial interview. I'm just waiting for that to be turned over. That's where we're at right now, Judge.
State, any comment?
That's correct.
Can you do me a favor? Just turn that on so that Mr. Corrales can.
The copy of the. Audio. Trying to.
Yeah, Mr. Herbert, will we turn yours on as well? Go ahead, Ms. Crave, you'll start over.
Thank you, Judge.
Can you say your name so we can see Mr. Corrales?
Hi, Tonda Curry, District Attorney. The audio or the recording that we have located of that custodial interview appears to be audio only. We're trying to determine whether there is a video that goes along with it, and then also whether or not there were any videos at the time that the accident itself was investigated.
All right, and do you think 30 days
More than
before would be sufficient?
Yeah, that'd be very sufficient. Judge.
Mr. Estrada, do you have your calendar available?
Yes, I do, Your Honor.
Let's look at August 8th or 10th to give you a little more than 30 days.
You said August 8th
Or 10th.
or 10th. Judge, Tuesday, August 8th.
All right, then the court's going to reset Mr. Flores Laredo for an additional pretrial hearing on August 8th. That will be at, let's see. Let's just go ahead and say 10:30 again. And I'm gonna check with my friends here at OCA to see if we have an interpreter that could be available for August 8th at 10:30. Thank you, Mr. Crosby. If you could schedule us for that, I'll go ahead and put that down. And if you need Ms. Tabraham to send a request, we can do that as well. All right, thank you, Mr. Corrales. Mr. Corrales, if you'll just ask Mr. Flores Laredo if he has any questions for the board or for Mr. Estrada.
Judge, everything is fine.
And forgive me for not knowing, are you bilingual, Mr. Estrada?
I am, Your Honor.
I thought so, but I didn't want to. Okay, all right, then the court's going to reset this case for August 8th at 10:30. Once Mr. Flores Laredo signs his notice of appearance, and he is free to go.
Thank you, Your Honor.
That might be excused.
Yes, thank you, Mr. Estrada. Good seeing you. Ross, how are you doing today, sir? Good. I think you're really busy. Or other boards you catch on to what a privilege it is to have you guys vote in Austin and handle this stuff for us. I said, have the other judges and other boards figured out what kind of privilege it is to have you guys come in and handle this from Austin for us. Good, good. Well, whatever we need to do to keep that the case, you let me know. All right. Good to see you later. See you. Mr. White, you ready, sir?
I am.
Ms. Robinson, we're ready for you, ma'am. Sorry, is there any kind of victim impact statement, or anything associated with this case? Sorry, is there any kind of victim impact statement anything associated with this case?
Your Honor, we sent out the statement in this hour.
All right, this is cause number CR 22-194, State of Texas versus Mary Lynn Robinson. Ms. Robinson, if you'll raise your right hand, I'll place you both. Ms. Robinson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God? All right, thank you. Mr. White, will you switch the microphones with her? Just, give her yours. Oh, okay, yes, yeah, that way it's not in her face, it'll pick up better, perfect, thank you. All right, Ms. Robinson, I have some questions for you. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes,
You feel like you've had enough time to talk with him about your case and that you've had all of your legal questions answered?
yes,
Is there anything about the paperwork that you've read over and signed today with Mr. White that you do not understand?
No.
Mr. White, do you believe Ms. Robinson to be competent?
Your Honor, I believe Ms. Robinson is confident that she understands the proceeding that are pending against her here today. And for the court, there is a number of ways. She's also executed a waiver knowingly, intelligently, voluntarily. Full understanding the consequences of waiving the rights. In addition, Your Honor, I explained to Ms. Robinson it's for communication that she completes the case or completes the probation. The case will be dismissed and show up as arrest and record. She violates any term of condition I explained to her that she is subject to the entire registration, which in this case would be 2 years in state jail facility and a fine not to exceed.
Thank you, Mr. White. All right, Ms. Robinson, to kind of echo some of the things that Mr. White has said, I do have to admonish you that you have been charged with a state jail felony offense of criminal negligent homicide, which, as Mr. White stated, does carry a range of punishment of not less than 6 or more than 2 years in prison if you were convicted and sentenced, and a fine not to exceed $10,000. I see the plea agreement in this case is the state's recommending that the court defer a finding of guilt. That means not adjudicate your guilt or convict you, but rather to place you on 3 years of community supervision in order you to pay a $1,500 fine plus court costs and reimbursement fees. Is that your understanding of the plea agreement, Ms. Robinson?
yes, sir.
All right, then Ms. Robinson, understanding the plea agreement, understanding the range of punishment. I would ask you at this time, how do you plead to criminal negligent homicide?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today?
No.
The court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence? Okay. State's evidence is admitted. Court takes judicial notice of the defendant's judicial position. Anything further from the state?
No, Your Honor.
Anything further from the defense? No. Let's review the evidence. Right, the court has reviewed the evidence. The court finds sufficient evidence to convict Ms. Robinson of this offense. Court will follow the plea agreement reached between the state and the defense. Court hereby defers the finding of guilt, criminal negligent homicide. Court places Ms. Robinson on deferred duty supervision for 3 years. Orders her to pay a $1,500 fine, $290 court costs, and $90 in reimbursement. Mr. White, has Ms. Robinson had her license revoked at all by the Texas Department of Safety? No, so she's still an active driver. And Mr. Hartwell, you said there's been no response by the family of the individual who was killed in this wreck.
That's correct, yeah.
State to sign all this paperwork as well. Ms. Robinson, court hereby remands you to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'll have you come forward to be fingerprinted by the deputies. After that time, you'll meet with Ms. Burns and she'll give you more information. CR 23-65. Mr. Nowak, the court has reviewed your request for court appointed counsel. Court finds you to be indigent at this time. The court is appointing the Honorable Richard Schmidt to represent you. Mr. Schmidt is not scheduled to be in court today, so I'm going to reschedule you for August 8th. And have you sign this notice of appearance? I believe Ms. Abraham's already given you paperwork with Mr. Schmidt's contact information, and some instructions, correct?
Yes, sir. It's right here, actually.
So once you sign this, then you'll get the yellow copy. You'll be free to go. And contact Mr. Schmidt according to those instructions. All right, of course, we're going to stand in recess for about 15-20 minutes to allow Mr. Manning to finish talking with his clients. Anything else to say at this time?
No, Your Honor, Mr. Zapp's is here.
Is he talking with her?
Yes, he's trying for her.
Okay, good. 15 minutes. Yeah, big work from so yeah.
Question about it, I'm trying to get the staff to find out where she was. Yeah. I just texted Miss Abney to see where she got that number from. Yes, she has no clue. Yeah, that'd be great.
All right, I'm sorry. Have a seat, but probably just a moment. We got an issue with paperwork. We can get that fixed. I'll call you back in just a moment. Manning, are you ready on this upright?
Yes.
All right, Miranda upright, CR 22-280, CR 22-281. Set for docket call, Mr. Manning.
Judge, we received a new offer today, in this. Like, an opportunity to consider that, new plea offer.
Objection from the state. All right, court will reset this upright for final docket call on August 8th. I'm sorry, August 10th. So upright, find that you're delinquent, your pretrial release.
Yes, sir, I took care of that this morning. I had the receipts.
Did you pay all 180?
Yes, sir.
Okay. So after you get your notice of setting, and then I want you to come over and meet with the pretrial release department. Okay?
Judge, we did that, took a chance to take forward, and I give you some of all things, and then we'll see.
All right,
Yeah.
you may. All right, this is, we're back on record cause number CR 20-326 and -239 State versus Johnny June Cooper Jr. Called the case earlier, received the announcement that Mr. Cooper has detained Mr. Weiner. Court's inquired into that retention. Court finds that, that may or may not have happened, not sure. Mr. Weiner's office can't confirm that. So what we'll do is we'll reset, Mr. Cooper for June 27th. Mr. Manning, you're still on the case. You've not been withdrawn from the case yet, but court. So we'll see if Mr. Weiner files a letter of representation or notice of appearance. Reset to June 27th at 9 a.m.
That way from what setting, Judge?
We're set for today, Dr. Cole. All right, Mr. Cooper, the court had you providing your analysis sample today in the pretrial release department. Mr. Waddell can confirm here. Mr. Waddell, if you'll raise your right hand on patient oath. Mr. Waddell, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God. I do. Mr. Waddell, you are the pretrial release officer for Johnny June Cooper, correct? Yes, sir. Court instructed you to conduct a urine analysis, drug exam on Mr. Cooper for compliance with pretrial release, correct? Yes, sir. Did you do so? Yes, sir. And what were the results of that test? The test results was positive for marijuana. And did Mr. Cooper admit or deny use of marijuana?
Mr. Cooper signed a way op form admitting use on May 11th of this year.
Mr. Maine, would you like to examine Waddell at all?
Yes, if I may have a motion, something like
Yes.
Mr. White, have you been supervising Mr. Cooper for the entirety of this case? This case,
Started a pre-trial last.
okay. And what was the date of that court date last? And did he admit to at that one time that he had used marijuana?
That's
Did you guys discuss whether or not he had used any of the substances?
he was not this last.
And was he on conditions of control release prior to May 11th of 2023?
That's
Okay. And so if he admitted to use on May 11th of 2023, but that means before the conditions of pretrial release had taken effect.
question.
If today he signed an admittance form that he admits to using or ingesting marijuana on May 11th, our last court date, that be prior to the signing and acknowledgement of the conditions of pretrial release in this case.
Not to my knowledge.
Now, what do you base your opinion on his admittance of the time of use of it?
Explicitly said that he used after work last, day before.
On the day of court last one, but he didn't say time of day or when he used at that time.
That's
Okay. So it's highly possible that he may have used before he came to court, found out he was using. The last time he used was May 11th. 2023, is that correct?
yes.
And was he advised of the consequences of signing an admittance form for use of marijuana back over a month?
I asked the last time he used that was the day.
If you give him an option for that to be sent off to be tested for the results of marijuana today.
That's
And was at any point in time that was not given an opportunity to discuss with him, advise him on the admittance of use on the
not sure I follow the question.
was he allowed to speak to counsel prior to signing that admittance?
That's
Okay. That's
Steve, do you have any questions of Mr. Waddell?
Where Mr. Cordell and whatever. And then that free provisions that.
I was not there.
See, the judge enters in there some conditions of pretrial release in July of 2020. July 10th, 2020.
what case was that in?
CR 2239. So here that they were signed by Judge Winners on July 20th. I'm sorry, July 10th, 2020. Signed by Officer Rachel Ventura and Mr. Cooper. I'm not sure of the date that they signed it. Looking at the file stamp, it was May 11th, 2023. He may not have signed his conditions of pretrial release until that day. All right, thank you, Mr. Winnell. Anything further, Mr. Trump?
Nothing.
All right, find that Mr. Cooper may not have had notice of his conditions of pretrial release. So the court's not going to find him in violation at this time. However, Mr. Cooper, you have signed your conditions of pretrial release and you know what you're supposed to do and what you're not supposed to do, correct?
Sir.
See you back on June 27th with Mr. Weiner.
All right, thank you. Good.
Mr. Haney, I know that that's not your typical day to be here. So, you don't have to appear unless I call you. It's just, I believe that Mr. Weiner probably has been detained.
And I was speaking to my client earlier, he said he believed that Mark may have been in the team.
That's what this information Ms. Abraham received. You're gonna go speak with Mr. McFarland, is that correct?
Judge, actually, it's just an initial information he signed with the changes that were done.
So we're ready to go.
Yes, Judge.
All right, Mr. McFarland, if you can get him a chair. Decide one, put him out of the way if he needs to sit. That's fine. This is cause number CR 22-335 and CR 23-105. State versus Benny William McFarland. On the charges of aggravated assault, deadly weapon, and unlawful possession of firearm by a felon. Mr. McFarland, you're welcome to have a seat if you want to, sir. Okay. All right, Mr. McFarland, just where you're at. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? And you have to say out loud. Okay. And Mr. McFarland, I have a few questions for you. Are you a United States citizen who reads, writes, and speaks English?
Yes,
Have you ever been diagnosed with a mental condition?
I thought,
Bipolar, depression,
I
schizophrenia?
don't think so.
Okay. And in this case, you're represented by your lawyer, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes,
Do you feel like you've had enough time to talk with him about the case? You've had all of the legal questions answered?
yes,
Is there anything about the paperwork that you've read over and signed today that you do not understand?
and let me ask him.
My client had a question. We are just proceeding under the lawful possession of firearm by a felon.
I don't know. I don't have any.
Okay.
Mr. Manning, you've indicated that the plea agreement today will be only on CR 23-105 unlawful possession of firearm.
That's correct, Judge.
So, Mr. Manning, you believe that Mr. McFarland is competent to enter into a plea agreement today?
Judge, I do, Mr. McFarland has had some recent health issues that have, slowed his abilities, but I still believe he does understand and has been able to interact, throughout his case, both in regards to defenses as well as, mitigation for this case.
Mr. McFarland, you understand that the plea agreement today is only on the third degree felony firearm by felon charge. That case would also resolve the aggravated assault deadly weapon charge. You would be admitting guilt to that, but you would not be pleading guilty to that. You would not be adjudicated and placed on community supervision for that charge. You understand that?
Well, I'm not pleading guilty on the aggravated assault because I didn't assault anybody, so that'd be a lie, so I can't lie in court.
That a straight dismissal or it says 1245?
I believe it's supposed to be a straight dismissal by.
I think she just left, so
I can't,
you'll need to get that squared away.
Yes, Judge.
All right, go ahead and have a seat, Mr. McFarland. We may have to come back this afternoon to finish this.
Yes, sir.
Short. All right, this is on call for CR 21-403, CR 21-406, State versus Kaden Robert Mitchell. Mr. Mitchell, you're good where you're at. Mr. Waddell, did you conduct your analysis exam of Mr. Mitchell? Yes. And what were the results? Well, let me ask you, you're still, I placed you under oath in the previous case. For purposes of this case, you're still under oath. Do you understand? Yes. Can you tell me what the results of the your analysis from Mr. Kaden Mitchell were?
results of the test was positive for marijuana.
Is there any discussion with Mr. Mitchell about that?
Yes, sir. The defendant admitted to use marijuana, but the date he gave would be December. December first was when he told. I asked. Use marijuana.
It's about 6 months ago.
Yes, sir.
Mr. Mitchell, report's going to find that you violated the conditions of your pretrial release. Find your bail to be insufficient, Mr. Mitchell. Or you be taken into custody today, and I'm going to order the state of Indiana to go ahead and appoint you an attorney. Or we'll find Mr. Mitchell to be indigent at this time. You may. All right, Mr. McFarland, the court's going to reset this plea agreement. I understand that there's some issues to work out between the state and defense. We're going to reset this to August 10th at 9 a.m. Once you sign and get your notice of appearance, you're free to go. All right, Mr. Zappa, Ms. Tyler, are you ready? Come on forward. I'll tell you what, Mr. Zappa, y'all can just come right up here while they're using. This is cause number CR 20-318. Come on, Ms. Tyler, you can move on. Let's go. All right, Ms. Tyler, raise your right hand. Place your oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth? So, sir. All right. Mr. Tapple, is this a? Ms. Tyler, you were on probation, correct? Pre-trial. Yes. All right, so Ms. Tyler, you previously appeared before the court and pled guilty to an offense in which you were then placed on the court's pretrial intervention program that was approved by the court. You were subsequently discharged from that program by the Van Zandt County Community Supervision Department. Now you're back on the court's docket. It appears that you want to enter into a plea agreement to resolve your case, wherein your case would be reduced from the original charge of a third-degree felony offense of possession of a controlled substance. I think it's actually a second. For a secondary felony offense of possession of a controlled substance greater than 4 grams, less than 400 grams, the plea agreement would be that charge would be to a lesser included offense of possession of a controlled substance penalty group 2 less than 1 gram, with your punishment being assessed under section 1244B of the Texas Penal Code, which means that it would be prosecuted and punished as a misdemeanor offense, with the sentence being 1 day in the Van Zandt County Jail. You would receive credit for 1 day of time served, and you're going to pay a fine of $500, $180 restitution, $210 reimbursement fees, $270 court costs, and $270 in probation fees. Is that your understanding of the agreement?
I do believe so, yes, sir.
Do you think about that? You're not sure about?
I asked the court, I don't have quite all the money today. If I could have maybe about a month to finish paying the rest, I have $1,000. So I think it would leave some $240 legally.
How much were you going to pay today?
1,000.
1,000. Yeah, whatever you can't pay today over that 1,000, meet with the court compliance officer, get on a payment plan.
Absolutely.
All right. Ms. Tyler, if you'll go ahead and raise your right hand, please. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? All right, Ms. Tyler, we've kind of gone through some of this before as far as your understanding of the offense. I'm going to ask you at this point, are you pleased with Mr. Zappa and the representation he's given to you in this case?
Sir.
Do you have any questions about any of the paperwork that you've read over and signed today?
I don't think so at the current moment.
You understand that you will receive a conviction for this offense, but it will be a misdemeanor conviction.
Yes, sir.
That would be a class A misdemeanor.
Yes, sir.
Mr. Zappa, do you believe Ms. Tyler is competent to enter into this plea agreement? Yes, Judge. You explained to her her rights and also the consequences of conviction. Yes, Judge. You believe that she understands all those? Yes, Judge. All right, and Ms. Tyler, I would ask you at this time, how do you plead to the class A misdemeanor offense of possession of controlled substance, familiar group 2, less than 1 gram? You guilty to that one? Yes. You. Has anybody threatened you, forced you, or pressured you to plead guilty? No. Right, then court will accept the defendant's plea of guilt at this time. Mr. Zappa, any objection to states 1? No objection. States 1, evidence supporting this plea is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense? No, Judge. Court's gonna review the evidence. It's been a moment since I reviewed it the last time. All right, court finds that there is sufficient evidence to convict Ms. Tyler of this offense. Court will follow the plea agreement in this case. Court hereby convicts Megan Fine Tyler of possession of controlled substance, familiar group 2, less than 1 gram under section 1244B of the Texas Penal Code to a class A misdemeanor. Court assesses her punishment at 1 day confinement in the Van Zandt County Jail, gives her credit for 1 day of time already served. Orders her to pay a $500 fine, $180 restitution, $270 court costs, $210 reimbursement fees, and $270 probation fees. All right, Ms. Tyler, you're hereby remanded to the custody of the Van Zandt County Sheriff's so you can carry out the terms and conditions of the sentence. So take your fingerprint. After that, you can go with this firm, we'll give you a copy of this, then you can go check clerk's office. Okay. All right,
I guess I'll be told where to go.
right across the hall, the district clerk's office. She'll be able to take her.
That's all I have.
Yes, thank you, Mr. Bevan. All right, so we got anything further? Back to the Sawcross sitting up here does not look very promising. Mr. Manning, are you ready on the Sawcross case? Yes, I think we've already reset her, haven't we? That's correct. All right, is Mr. Waddell here, or Mr. testifying. Call number CR 22. Do you need Ms. Albright with you? Mr. Manning? Ms. Albright, go ahead and step over there, Mr. Manning. Call number CR 22-280, CR 22-281, State versus Miranda Jill Albright. Court's already reset Ms. Albright for docket call on August 10th. However, the court had a request for UA from the pretrial release department. Ms. Burns, if you'll raise your right hand on the picture of oath. Ms. Burns, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Ms. Burns, did you conduct your analysis test on Ms. Albright?
I did administer a UA test today and she tested positive for amphetamines. And I asked her if she likes use, and she did not use. So I packaged it and sent it out to
you have any questions, Ms. Burns, Mr. Manning?
Yes, Mr. Burns, are you aware of the error, range of error margin for the field test that y'all use, for your analysis?
Possibly have an expert.
Okay, so you admit there's a possibility that there may be a false positive, and what are some causes for a false positive on your analysis? Yes. Would a number of medications possibly cause a false positive for your analysis? And did Ms. Albright mention that she was on a list of medications?
She did.
And do you recall what those medications were?
She said she was on that.
I have some of this.
Mr. Harwell, do you have any questions, Ms. Burns?
I don't, sure.
And Ms. Burns, did she provide you a list of medication she was on?
She did.
All right, courts, I'm going to direct the probation department, pretrial release department to send that sample off for testing. The court's going to find that Ms. Albright has violated the terms of her pretrial release conditions. The court's going to order her to be taken into custody, depending on the results of their lab confirmation. Before we'll reconsider that if there's any error in the testing or a negative finding by the lab.
Before we do that, can we give my client an opportunity to testify and establish a record of her medications?
Let's do that this afternoon.
What?
Jill. Listen to Mr. Manning, he's gonna be out of the jail this afternoon. That'll give you all a chance to give testimony, and you can provide medications and all those things. Listen to Mr. Manning. Okay. The way that you're responding right here is a common way that people who are on methamphetamines respond. So the more you do this, the more convincing you are to everyone around here that you violated the conditions of pretrial release. Listen, begging and pleading is not gonna get it done. Listen to Mr. Manning, we're gonna have a hearing this afternoon, all right? I may reconsider then, but you need to do what I tell you right now. Okay? Mr. Manning, I'll add her to the second.
Thank you, Judge. Unfortunately, that's the same.
Deputy Martinez, when you get a chance, I know you're busy, man. We'll go ahead and call that voice name, I believe, and I think that'll include our. Where do we need to his name just in case? Lights out here, Michael's. Michael's. Yes, yes. Michael's. He's. Thank you, Deputy Martinez. The court has called Cody Lee McCoy and Michael Zimmerman at 9 a.m. They were not present at this time, which is approximately 12:20 p.m. Court said their name called loudly and distinctly 3 times in the courthouse with no response. Court hereby issues a judgment not signed alias KPS for each of those individuals. That will conclude the morning docket. We will resume at 1:30. Advantage, thank you.